Welcome to Business Legal Lifecycle TV, the live TV show all about the legal aspects of your business to help educate you on complex legal terms in an easy to understand manner, to help understand why you need to do certain things in your business from a legal point of view, and to help you develop a plan for the future. Our mission at Business Legal Lifecycle is to help empower all small to medium-sized businesses around the world to get access to legal advice so that they can help build their communities and make the world a better place. Did you know that any business owner is on average 7 months away from losing everything? That is the average time it takes from a successful business to fold when an aspect of their business is not set up correctly. Have you ever wanted to get legal advice but didn't understand what was going on? Do you feel like there is a divide between lawyers and their clients? Then this TV show is for you. It is all about empowering you and your business with the knowledge and tools to ensure that this doesn't happen to you. Business Legal Lifecycle TV delivers a twice-weekly show focusing on the legal aspects of your business. At lunchtime on Mondays, we present Fast Fix Monday, a quick 5 to 10 minute show that will give you some actionable steps to consider for the week for your business. And at lunchtime on Wednesdays, we present our in-depth show of between 30 minutes and an hour, where we go through complicated legal aspects of your business in a simple to understand, plain English manner. And whether that is through educational pieces or interviews with experts in their fields. Hi everyone, and welcome to Business Legal Lifecycle TV. My name is Jeremy Stratton. I'm one of the founders, and it's just me today. Today we're going to do a presentation in relation to phase 6 of the Business Legal Lifecycle on agreements with investors. So just for people who are watching, I'm moving over to the slide showing the Business Legal Lifecycle. If you are listening to us on the podcast, welcome, hello, and check out businesslegallifecycle.com.au for a copy of the Business Legal Lifecycle and what the actual image of the Business Legal Lifecycle is. This is being shown live in January 2018, and the theme this month is all about phase 6, which we call maximizing your business and bringing in investors. So phase 6, if you can see the graphic or if you're familiar with the graphic, you'll know that phase 6 is at the bottom of the business legal lifecycle. So why is that? When I say the bottom, the first 3 phases and the 4th phase lead up to the business legal lifecycle hitting a peak, and then it comes down. And those phases 4, 5 and 6 are all what we call the consolidation phases. And there, after you've started your business, it's about consolidating your business so that if you choose to, you can go and scale it, which are the next 4 phases. So phase 6 is all about making sure that you've got everything in place properly for your business. One of the key aspects of that is often, and it does not have to be, agreements with investors. So if you're a business owner and you don't like the idea of having other investors in your business, then look, to be brutally honest, this podcast and this show may not be for you. I'd encourage you to listen to it, of course. I'm putting it together. I'd encourage you to listen to this podcast or listen to watch the show where I go through the different types of agreements, because one might come up that you hadn't thought of before. Investors aren't for everyone. We've been through before some choices that people have made in relation to investors. Making sure that you've got the right type of investor and some criteria for those investors. If you want to check any of that out, please go to businesslegallifecycle.com.au/BLL-TV-index, and that has a full index of all of our shows. This is show number 52. Or you can, if you're listening to the podcast and you're interested in any of the previous ones, please go to Apple Podcasts. So as I said, today's show is about the agreements with investors. And so this is all to do with the agreements that we put in place for clients from a legal perspective and the kind of things that you want to have to look out for. So I'm going to go through 3 different types of agreements. The first one is a shareholders agreement. The second one is a joint venture agreement. And the third one is a loan agreement, because investors can invest money in your business in those 3 ways. Now, there are many ways to be right. And the right type of investor for your business may be different to the right type of investor for your friend's business or your colleague's business. So you need to work out what the right type of investor is for you to make sure that you can set up your business for success and that you do it properly. So today I'm going to go through a little bit of a format in relation to each of these agreements. As always, please feel free to ask questions if you are watching this live. If you are not watching it live, and you're watching this on Facebook, please make a comment or send us a private message. We're more than happy to help. We're all about providing as much information that we can to you, our watcher or our listener. If you're listening to the podcast, please email at lifecycle@jeremystretton.com. And I'll be happy to answer any questions that you've got about this. One thing to notice, and I will talk about this a little bit as we're going through the different types of agreements, but there are, as I said before, there are many ways to be right, but every individual circumstance is different. So if you're a regular listener to the podcast or watcher of the show, you'll know that Craig and I often talk about the different types of agreements that you have to have in place, why they're important, and why your circumstances might be different to your friend. Because often what we do in business is we have our friends, our colleagues, the people who are well-meaning people who have been through business before, but they don't understand your initial circumstances. To give you an idea, I was recently advising a client in relation to a loan agreement, and he'd gone and spoken to a friend who said, look, great having a loan agreement, but you also need a personal guarantee. What the friend didn't understand was that the loan was from the actual person and the individual behind the personal guarantee, behind the company. So rather than a company borrowing money and getting a personal guarantee, that wasn't necessary because the person who was operating the business was actually the one who was the person who was being lent the money was actually the one behind it. So a personal guarantee wasn't necessary. So you can see just from that short example, and I'll give some other examples as we're going, but that short example that circumstances do change and you need to get advice from someone who knows what they're talking about. And that's really the key. So make sure that if you're not sure, that you get the right advice from someone who you know, like, and trust, and that you make sure that you're able to get the right advice and follow the advice that you get. So without any further ado, I'll go into the different types of agreements. So the first agreement is a shareholders agreement. So what is a shareholders agreement? A shareholders agreement is a contract between the shareholders of an agreement about how that company or business is going to be operated. So a private company, when you set up a private company, so here we're talking about not a public company, but a private company that's operated by a certain business owner, when you set that up, often you'll have what we call a constitution, or you might be the company might be governed by what we call the replaceable rules. So the constitution will be about a 30-page document normally. It's usually pretty what we call vanilla in the sense that it's pretty regular and pretty standard across many different types of businesses. And it sets out the general rules and the operation of the company. Where you bring in an investor though, you need to think about the actual terms of the shareholders agreement and a lot more little factors. And you can really customize your shareholders agreement to make sure that it's entered into voluntarily and that it's fair and reasonable and does what everyone wants from their business. So essentially, it stipulates the rules and policies and processes that will fall outside the normal legal parameters. I mentioned before that you could also have what we call the replaceable rules. The replaceable rules are the rules that are set forth in legislation called the Corporations Act in Australia, and I know that there's other legislation around the world, and they actually set out some basic rules that you can have for shareholders agreements or for the operation of the company. So I'm going to go through what you need in a shareholders agreement, but let me just talk about why you need a shareholders agreement. You need a shareholders agreement because it regulates the rights, obligations, and relationships between the shareholders. It provides a common understanding among founders and investors, and it regulates the day-to-day operations of the business. It also formalizes the processes to follow when an investor wants to leave the company or when another investor wants to buy in. It also can govern things like the sale of the business and other things like that. It's not a simple agreement. Anyone who tells you that it's a simple agreement is not telling you the truth, or they don't know what they're talking about. A shareholders agreement is a complex agreement that requires quite a considerable degree of legal thought, and really you can get vanilla generic ones on the internet and you use them at your own peril because they really need to be structured to meet your specific demands. So you need to value the advice that you get from your legal advisors and make sure that your shareholders agreement is fair and reasonable for what you need for your business. Now, as I said before, if you've got multiple shareholders and investors, then what I have found is the process of actually entering into a shareholders agreement and negotiating a lot of the points that we put into a shareholders agreement is actually half the battle for a startup business. So half the battle is actually making sure that all these questions have been answered and considered as you're going through the business. So you'll see this from the things that I'm going to talk about. So a shareholders agreement deals with the answers of what if. And a lot of these agreements and a lot of what we do as lawyers deals with the what ifs in life and what happens if something actually goes wrong or something happens to a person. So you need to think about these what ifs. What if a founder leaves, dies, or becomes chronically ill in the business? That can often have a terrible effect on the business. What happens if a founder decides to start another project similar to the business? Let's face it, most of us entrepreneurs often have great ideas, multiple of them, and we decide that we need to keep going with that business, or we have another shiny object. So you need to have some rules around what happens if another great business venture comes up into place. What happens if you need a new partner? So what are the rules about bringing in a new partner, and what are the criteria for finding them, and how do they come into these kind of agreements? What about the rules relating to a founder or an investor not dedicating enough effort or finds another job? You really need to set out early on in business who's doing what, especially when you've got multiple people, so that the roles are clearly defined. All of the examples that I can give you are where businesses have failed is where they haven't had a shareholders agreement, or where they have, but they haven't properly defined what actually happens in these things. Sorry, just let me have a drink of water. Also, what happens if a founder or an investor is not delivering? So often, if you've got founder and investors who are going into business together, they will often bring different strengths and weaknesses into a business. So you need to think about, well, what's the consequence if that founder or investor doesn't deliver on what they've promised? These things need to be set out as what-if moments so that you don't have a legal dispute, because what happens if you don't have it is you end up in court and you end up paying lawyers thousands of dollars, which, quite frankly, whilst it's good for my bank balance, it's not good for you, and it's not good for your continued business operations and what you wanted to do in your life. So you need to make sure that you've thought about these things, and also thought about, probably the most important one, is what happens if there's a deadlock. So if you're a 50-50 shareholders, business partner, and you've got 50-50 shareholders, and then you've got two directors, the decisions that need to be made in relation to the company need to be, in relation to the day-to-day operations of the company, need to be made by the directors. If you have two directors who can't agree on something, then you have a deadlock. If you have shareholders who are equal, then you can't change the directors to try and bring in another director, or to remove a director who's troublesome. If you've got 50-50 shareholders, then you have a deadlock. So you need to think about what happens there. Now, I'm the first person, when I'm advising clients, to be very wary of a deadlock procedure. So if you're aware of a deadlock procedure, some of them can be 3-4 pages long and mean nothing. You need to have a really short, fast, sweet deadlock procedure. I often call what we call the shotgun procedure, which is often where you'll have two investors, and you'll say, if you guys can't agree and one person wants out or one person wants the other party out, then party A makes an offer to party B. That offer, though, has to be something that party A is willing to accept in return. So party A offers $50,000 to go out of the business. Party B has to be able to offer 50 grand back to buy out party A. That eliminates all of the nonsense negotiation that happens, and it also means that party A is making a valid offer to party B that they're willing to accept. That can be a great way to short circuit a lot of the common problems that we see in shareholders' deadlocks, and is really quite an effective way of resolving these disputes. Be wary of the 3-page, 2-page, even 1-page deadlock procedures that provide that you're going to go and see a mediator here, then after that you've got to get a certificate from the mediator, then you go to court, and this is the process the court's got to follow, because they aren't really binding. And the courts have found in the past that it's all well and good for the parties to agree to this procedure, but if that procedure isn't fair, if it's not really binding, then you don't have to follow it. And it's a lot of stress to get nowhere. And it can also cause problems later on. So you need to have a think about all those kind of things. The other thing that you might want to think about is what we call a buy-sell option agreement. And a buy-sell option agreement is an agreement where basically if something happens, the death, incapacity, or something else of a shareholder, that it could be an automatic trigger event for the investor to sell their shares to the other party. If you're interested in more about that, I'm happy to go into a bit more detail for you. They are a little bit complicated. They require insurance and various other things. So I'm going to park that right now and say that if you are interested in a buy-sell option agreement, which are very important, and it's very important to have some sort of procedure in place where you've got a business, if something, especially if someone dies or is incapacitated, then you need to have a think about that and get some proper advice. Doesn't have to be me. Go and talk to your lawyer, your commercial lawyer. Any of them will know what a buy-sell option agreement is. Even your financial planner will probably know what that is, because often the payment under the buy-sell option agreement will be from an insurance policy, and so a personal insurance policy to pay out on your death. So those kind of things all need to be considered. So I thought I'd go through the different types of shareholders agreements and then go through some of the general provisions that I think are important for a shareholders agreement. So probably the first type of shareholders agreement is an early stage agreement. So, and the reason this is important to think about is that in any business, you're going to have different levels. So, the business legal life cycle talks about 13 different phases, but even when you go through different phases, you might have different shareholders agreements. So if you're in an early stage business, so a startup business in phase 2, and you've got multiple investors, then you'll have a certain early stage agreement. And it's really going to deal with really the fundamental things that happen with the business. But it's not the kind of thing that you want to do and then leave for another 30 years, 10 years, 5 years even. It's really something that you want to be on top of and that you want to be reviewing on at least every couple of years. Because as the business grows, the responsibilities, the roles, and what the people want to happen changes throughout the agreement. So it is something that, whilst you want a shareholders agreement that does cover a lot of different scenarios, that actually does it does get reviewed on a regular basis, because when you get through the growth phases, so when we're talking about here, the consolidation growth phases, you really need to start thinking about that and changing that, because you might have different investors, you might have different business people, your goals might have changed. Often a shareholders agreement will set out the goals for a business, and then it will also set out the what needs to happen for when those goals are reached. You might change your mind. You might reach those goals really easily. You often hear about businesses that set up, and I think I listened to a podcast just yesterday, and it was How I Built This, for, the NPR podcast, which is great. If I can recommend one for anyone, listen to the How I Built This podcast. It is awesome. And the LinkedIn founder was on yesterday, so this is it was the 15th of January 2018. And he was talking about the fact that they had a certain goal and then they smashed it by about 3 or 4 times. And in that situation, whilst it doesn't happen all the time, you need to change the way that you actually structure your business and how you structure the affairs between the parties. And that's really important. So make sure that you're thinking about that as you grow, and don't just assume that everything's right, because what if something goes wrong? That's why you need an agreement. That's why you need to make sure that it's all set out correctly. So I thought I'd go through just a couple of important points for a shareholders agreement, and then I'll move on to joint ventures and loan agreements. And look, the main focus today is the shareholders agreement, so I know that I'm dedicating a lot of time to it, but when you're bringing in investors, it really is key. So the first thing is the board of directors. So in any small company, when you start out, if you start out as a solopreneur, as we like to call them, you might have one director, or you might have 2 if you've got 2 people in there. When you're bringing in investors will often provide you with a sum of money. And in return, they want some shares back. And depending on the amount of the investment and the control that they want to have in the company, they might ask to be on the board of directors, and be a director. If that happens, you need to decide, well, what does that board of directors actually look like? What are the decisions that are going to be made by the board of directors? Who gets the right to make decisions? If there are 3 directors, is it majority rules? If it isn't majority rules, or it is majority rules, either way, really, are there decisions that majority rules applies to? So you might have a business in a startup phase that might have a $10,000 limit. So the majority directors can incur $10,000 for the company, But when you're in this kind of phase, when you're getting ready for growth, you might decide that a majority of directors can decide $500,000 decisions. That depends on the type of business. It depends on what supplies you need for your business. It depends on what your costs are on a regular basis. So there are many different things that need to be determined there. But you need to have a think about what the election looks like, how the decisions are going to be made, and what those and who gets to make those decisions. Next is voting rights. So, if you've watched any of our earlier shows on company structures, you'll know that a company has directors and shareholders, and I mentioned that earlier. This is a shareholders agreement, and there will be certain decisions that you won't want directors making that you want the shareholders making. When you have those decisions, the voting rights become very important. Again, if you have two shareholders who are 50-50, then normally all decisions need to be made by a majority plus one. So that's 50% of the shares plus one share. Not 51%, 50% of the shares plus one. If that happens, say if you've got 50-50 shareholders, and then we go back to what happens with a dispute. But you might also have, if you've got 3 or 4 investors, you might have decisions that need 75% of the vote. So you need, and 75 plus 1 vote. So 75%, so if you've got 75 shares, then you need if you've got 100 shares, then 76 votes need to be passed. If you've got 1,000 shares, then 751 shares, the holders of those need to vote to agree to these decisions. So you can see that there are minute details that you need to be aware of to make sure that you understand all of the differences. The next thing that's really important is what happens when people want to transfer shares. In a private company, you can't just go selling your shares on a stock exchange. You've got to sell them privately. So normally what you'd have is what we call a first right of refusal, to say that a shareholder can't sell their shares unless they first offer those shares to someone else, one of the other shareholders normally. You need to think about that procedure. You need to think about, well, what happens if someone does transfer the shares to someone else? And you've got to think about what happens as the procedure on the sale. So that's really important. Tied into that are share valuations, discounts, and cash flow. So share valuation, so if you're selling shares, how are you going to work out what the actual value of the share is? If there's a discount, especially for an early stage business or an early stage investor, if they're going to just get their money back, or what they're going to be paid out when they sell their shares. And also you need to think about things like cash flow. We once acted for a gentleman who we were doing some estate planning for him, and he had a very large company worth a couple $100 million. And his concern, it was a large property development company, and his concern, once we dove really deep into it, was what happens, he had 3 kids, what happens if one of the kids took their share and said that they wanted to sell that share and they wanted out? Well, that was going to be difficult because this was a very land-rich company. It had lots of assets, but it didn't own much in the way of cash. So what does that mean? Well, that means that we had to put a procedure in place to say, well, if you want to get out of the company, then you need to wait for the company to have the cash to be able to pay you out of the company. So you need to think about all those things to make sure that what is put in place is fair and is practical. And let me just say that again, it needs to be practical. You need to have a procedure in place that's practical so that you're not going to have a fight, because it's when you don't have things that are practical that is a problem. Dispute resolution, again, I talked about this before. Dispute resolution clauses are great. You need to have a procedure in place, but I think you're best off having some sort of shotgun procedure that just ends everything straight away. Stop any nonsense, stop any disputes, and just end it straight away. You can have a complicated procedure if you like, but I think that's a much better way of doing it because it resolves most of the disputes. I can tell you that in the businesses that I'm in, that's what we have. We don't have complicated dispute resolution clauses. All right, so that's probably enough on shareholders agreements. I've talked about that a lot. The next type is a joint venture. So going back to our earlier shows on startup, you may recall if you listened to those, and again, feel free to go back and have a look at the TV index on the Business Legal Lifecycle page. If you are watching this on the Facebook page, it is the pinned post. And if you're listening to it on the podcast, please feel free to go to the Business Legal Lifecycle page. Please like it. We do post a lot of content. And the pinned post at the top of the Business Legal Lifecycle page, Facebook page, is the TV index. It's a link to that index. So joint ventures, just to give you a broader overview, is different to a shareholders agreement because a joint venture is 2 companies coming together. So rather than having a company over the top. You have two companies that come together, or two businesses, or two people, and they enter into a joint venture. And rather than the company being the vehicle by which the joint venture is operated, it's just the two companies together. It's like a partnership. But a partnership implies, for those of you who don't know the legal terminology, a partnership implies that you're working exclusively in that partnership together, whereas a joint venture implies that you've got a joint venture with two parties who might have multiple business ventures around the world, or around the country, or around the city, or around the state. So a joint venture, for that reason, is very similar to a shareholders agreement. It is very similar. You need to think about what the purpose of the joint venture is, who's going to pay the costs. Now, the reason that these things are all important is that in a shareholders agreement, you have a constitution which deals with a lot of the fundamental bits and pieces that go into a business. You need to put all those things into a joint venture agreement to make sure that it operates properly. Joint ventures normally operate by property, so I had properties in my mind. So the purpose is important. Who's going to pay the costs? What happens to the proceeds and losses? So a joint venture would normally be for a project, say a property development, for instance. What happens with the proceeds and losses? You need to think about the responsibilities. So who's doing what? That's very important in any of these types of agreements. You need to think about the principal place of business. You need to think about the bank account. What the actual bank account in the business is how that's going to be set up and how that's going to be operated. You need to think about your accounting and records. You need to think about your operating committee. So operating committee are essentially the directors. You need to think about the capital. Who's going to put capital into the joint venture and who's not? Who's going to put any encumbrances on the property? What they actually mean. What happens if someone wants to assign or transfer their interest in the shares, and also, again, dispute resolution. All very important things to have in a joint venture agreement, and are things that are often missed very, very often. So if you are interested, go back and listen to the shareholders agreement, or look at our show notes. We'll be posting the show notes. If you're listening to the podcast, they'll be on the podcast. If you're watching us live or watching the video, you can check them out. They'll be on our website, and I post those usually on later in the week once we've put them together. So you need to think about all of these bits and pieces to make sure that you govern the relationship properly, and you're thinking about, well, what if something goes wrong? Let's have a drink of water. So you'll remember from the beginning that I said that in any business, there are three different types of ways that an investor can come into, and the third one is a loan agreement. So often an investor won't want to take any equity in the business. They'll just want to have a loan to the business. Now, we've talked about this before in our earlier shows, but a loan agreement is essentially a loan of money, usually. If you're investing in a business, it's going to be money. It's not going to be your time. You might invest $500,000 in this business, and you loan that money to the company. So if you're loaning the money, you need to think about what's the amount, when's that amount due, what are the repayments, what's the interest rate, is it principal and interest only, what security is going to be in place. If I'm acting for a lender, I will always want security. Is that going to be security over a property, which is strongly recommended, or is it going to be a fixed and floating charge over the company? All those kind of things matter. And also what happens if there's a default. So what security can be sold and all those types of things. So loan agreements are a very common way of people investing money. If you're the person borrowing the money, you need to be really careful to make sure that the loan is fair and reasonable, and that you're not giving up any equity in the business, and that you're going to be able to repay it. Sorry, just thinking about that. That's a really important point. Make sure that you're actually able to pay the loan agreement back when it's going to come back. If you're the lender in that scenario, then you want to be thinking about, well, what happens if the person doesn't pay? Using the example that I gave right at the beginning of this podcast and TV show, what happens if the person is a company that's lending the money? What personal guarantees have you got in place? So thank you very much for watching or listening to today's show. This is a topic that I really have quite a big passion for. I think one of the biggest reasons for business failure we know is a lack of planning. And a lot of that comes from the fact that business owners don't plan out what they do, and they also enter into agreements with other investors that end up backfiring because they haven't thought about what's going to happen and some simple procedures that need to go in place to protect both parties or multiple parties if there's a default. So I hope you enjoyed today's podcast. As always, we'll put the show notes up, and they'll, as I said before, they'll be up there in the next couple of days. And if you listen to the podcast, you'll get those straight away. As always, feel free to email me at lifecycle@jeremystretton.com, or post questions on the Facebook feed. Happy to help out. This is a very important area, and you need to make sure that you get it right. So thank you very much for watching or listening, and we'll be back next Monday with another Fast Fix Monday. I'm Jeremy Stratton. Enjoy the rest of your week.